Ruth Bader Ginsburg is an Associate Justice of the United States Supreme Court. She became the second ever female Supreme Court Justice when she was nominated by President Bill Clinton in 1993. She had been serving as a judge on the D.C. Court of Appeals since 1980 when President Jimmy Carter first appointed her to the bench. She also had a distinguished career as a law professor at Rutgers University and later at Columbia Law School. Her early career was defined by zealous advocacy in gender discrimination cases, earning her a reputation as the Thurgood Marshall of the women's rights movement. My Own Words is her first book since becoming a Supreme Court Justice. It is a collection of her writings and speeches. I met with her at the Supreme Court on the occasion of the book's publication, and here is that conversation. Justice Ginsburg, thank you so much for this opportunity to talk to you.
It's a pleasure to talk to you, Charlie.
Thank you. This, My Own Words, Ruth Bader Ginsburg, written with Mary Hartman and Wendy Williams. This is the first book you have written since being a justice of the Supreme Court.
Yes, not the first book ever. The first book was the bestseller called Civil Procedure in Sweden.
I missed that one. But you've always been interested in procedure.
Yes, I taught procedure for 17 years.
At Rutgers and Columbia?
At Rutgers for 9 years and 8 years at Columbia.
Yeah. It's called My Own Words, and this is a collection of speeches that you have and writings about you and about the law. When did this love affair with the law, how did it begin?
My interest in becoming a lawyer was sparked in the 1950s when I was a student, an undergraduate student at Cornell. It was the heyday of Senator Joe McCarthy. It was not a good time for our country. There was a huge Red Scare, and people were being called before the House Un-American Activities Committee, the Senate Internal Security Committee, and interrogated about some youth group that they belonged to at the height of the Depression in the 30s.
And lost their jobs.
Now, there was a blacklist in the entertainment industry, but my professor of constitutional law, for whom I worked as a research assistant, brought to my attention the lawyers that were appearing before the people, called before the committees. Lawyers who reminded Congress we have a First Amendment and we have a Fifth Amendment. And they were straying very far from those fundamental precepts of our system.
You saw the law as a protector of individual liberty.
Yes, yes. I thought it could be a way to make a living, plus to do something that would make conditions in your society a little better. So that's what led me to take the LSAT when I was a junior. The LSAT is the law school aptitude test when I was a junior at Cornell.
Now, you were at Cornell for 50 to 54.
Yes.
There was another student at Cornell.
Yes.
Who decided to become a lawyer, too.
Yeah, my dear husband.
Your dear husband.
Yeah, in fact, we had decided that whatever we do it together. Medicine dropped out early on. Marty started out as a chemistry major, but his true major was golf. Yes. And labs were in the afternoon and interfered with golf practice. So then it was either business school or law school. In the 50s, Harvard, for some reason, Marty was determined that Harvard was the right place for us, but the Harvard Business School didn't admit women until the middle 60s. So the law school. And I was very pleased that was, because that was my number one choice.
So you both set off for Harvard Law School?
Yes. We did not immediately. We married the same month I graduated from Cornell, and then we had a gap period. We had 2 years, 1954 to 1956, in the U.S. Army in Fort Sill, Oklahoma, the principal artillery base in the United States.
Right. He became a great chef. There's even a book called Chef Supreme or Supreme Chef. His recipes, he cooked until he died.
Yes.
Was he cooking then? Was he a great chef then, or was that an acquired talent by him?
He was learning then. I had a cousin who sent Marty the Escoffier cookbook in English translation, Escoffier, the great French chef. Yeah. And Marty treated it like a chemistry text. He started with page 1, the basic stocks, and then he moved on to sauces. In the course of 2 years, he became an excellent cook. I still have the Escoffier cookbook that he used. It's falling apart. It has food stains to show how well used
When I met you in the chambers, you saw the book, and you said that what happened in your life is that you were the weekday cook, and he cooked on weekends and for special occasions and special visitors.
For any visitors, I was never allowed to cook for guests.
But at some point, your daughter basically said, we don't want you to cook anymore.
Yes, because Mommy had a routine. I had 7 things that I made, and we got to number 7. I went back to number 1. The only cookbook I used was called The 60-Minute Chef. That meant from the time you entered the apartment until dinner's on the table, no more than 1 hour elapses.
You then transferred to Columbia Law School. You're at Harvard.
Yes.
And you transferred to Columbia.
Yes.
Both great law schools, but why transfer?
Marty was 1 year ahead of me. He had had his first year at Harvard and then was called into service, and so we returned 2 years later when I started. So he was 1 year ahead of me. In my second year, his third year, he had a virulent cancer. He had a testicular tumor, and in those days, it was most uncertain whether he would live. There was no chemotherapy. He had massive surgery, massive radiation, and we wanted to be together for as long as he would live. As it turned out, he lived many, many years after that. He was one of the first survivors of that form of cancer. And Jane was then 3 years old. My daughter was 3 years old, and I didn't want to be a single mom. So I left Harvard and asked if I could have a Harvard degree if I successfully completed my legal education at Columbia. The answer from the dean was, absolutely not. You have to spend your third year here. And I said, but you accept transfers into the second year. You say the first year is by far the most important. You'll give a degree on the basis of year 2 and 3, but not 1 and 2. That doesn't make sense. And I was told a rule was a rule, and that was that. I went off to Columbia. I didn't ask if they would give me a degree because contemplating 3 years of law school and no degree from either institution was just too much.
Sure.
But Columbia gave me a degree. They transferred me from the Harvard Law Review to the Columbia Law Review. Columbia was very good to me.
And Harvard didn't give you a degree. And then Marty comes to you, though, and says, don't go back and accept anything from Harvard unless they're willing to give you an honorary degree.
Well, what he said, when my dear colleague Elena Kagan became the dean of the Harvard Law School, every year while she was dean, she said, Ruth, we would love you to have a Harvard Law School.
We'd like to make amends.
And Marty said, hold out for an honorary degree, which I received in 2011.
And there's a picture in your chambers of you and Pastor Domingo.
Yes.
And he's singing to you.
Yes. In the
red Harvard graduation robes.
Yes.
And your title for that picture is what?
Woman in Ecstasy. That's me. I had no idea. It was a thrill enough to know that we would be seated next to each other because they lined us up in alphabetical order. So Domingo was just one ahead of Ginsburg. But then when they called me to receive my honorary degree, and he stood up and goes to the microphone and sings words that the students had written to the tune of Celeste Aida, one of the most famous tenor arias in the world. It was a thrilling moment. It was his being so close to that great voice was like having an electric shock run through me.
And we've now talked about three of the loves of your life, Marty, the law, and Domingo in opera.
Yes.
So you went to teach at Rutgers and then Columbia. Why teaching?
I wanted to be a law teacher eventually. My plan was that I would work at a law firm for about 5 years and then go into teaching. Teaching is a very good life for someone who likes to read, who likes to think, and
who likes to write.
Yes. But I had an offer from Rutgers in 1963 at a time when there were perhaps 16 women teaching in tenure positions in law schools from coast to coast. So there was a bird in hand. Would I get another offer, say, if I went to a law firm and waited 5 years? So I took the Rutgers offer in 1963 and remained there until 1972, when 1972 was the year of the woman. Every law faculty in the country was looking for its woman.
And Columbia came looking for you.
Yes.
When did you get drawn into the women's movement?
In the late 60s. Well, I began to think about it in the early 60s when I was in Sweden, because Sweden had already gone much further than the United States in opening opportunities for women. So I observed how people were living, but put it on a back burner. In the late 60s, the women's movement came alive again, and it was my students who propelled me into this line of inquiry.
Asking for legal advice?
Asking for a course on women and the law. Oh. So I went to the library, and inside of a month I had read every law review article, every federal decision that had to do with gender-based differentials. It was no mean feat. There was precious little there, and all of it was bad. All of it was whatever lines based on gender that the law draws, it's okay with the courts. So my students wanted to have a course on women in the law. I prepared for that. At the same time, new kinds of complaints were coming into the New Jersey affiliate of the ACLU. Women who were school teachers and were pregnant and were being forced onto so-called maternity leave as soon as they began to show in the 4th month or the 5th month. The leave was without pay, and there was no guaranteed right of return. As school teachers were not pleased with this arrangement. They thought that they were ready, willing, and able to work, and there's no reason why they should have to leave the classroom just because they were pregnant. Another group were blue-collar women whose place of work had good insurance coverage, health insurance coverage. So these women wanted to have health insurance coverage for their families. The employer's rule was family coverage is available only for a male worker because the woman was not considered the head of the family. She was a pin money earner. She could get insurance for herself, but not for her family. So those new complaints were coming in, complaints that women finally had the courage to voice. It was the the new clients and my students that propelled me into.
And so you not only taught a course, you started a review,
yes.
And it became really, it seems to have become the driving purpose and the driving cause of your life.
I had a fantastic opportunity. There was a real possibility that there would be change in the laws. Feminists had been saying the same thing that we said in the 70s, generations before, but society was not yet ready to listen. Think of Abigail Adams,
yes.
Told John to remember the ladies, and he didn't. But in the 70s, the women's movement was coming alive all over the world, not just the United States. The United Nations had declared International Women's Year.
Right.
And we had just had the experience of the civil rights movement of the 60s. So it was possible in the 70s to move the court away from the notion that whatever sex lines are drawn in the law, they are okay.
This was the Burger Court.
The Burger Court, yes, the Warren Court.
This was not the Warren Court.
The Warren Court's one contribution was in a case, Gwendolyn Hoyt's case. Gwendolyn Hoyt was a woman, we would today call her battered. She had a husband who was philandering, who was abusive, who one day had humiliated her to the breaking point. She spied her young son's baseball bat in the corner of the room. She took it, and with all her might, she hit him over the head. He fell against a hard floor. End of their fight, beginning of her murder prosecution. Florida at that time didn't put women on the jury rolls. And Gwendolyn Hoyt's view was, if there were women on the jury, they might better understand what was in my mind, my rage at that moment.
But she was convicted by 12 men.
Yes. She didn't think that necessarily women would acquit her, but she thought that at least they might come in for the lesser crime of manslaughter, not murder. She was convicted of murder by an all-male jury. Her case comes to the Supreme Court, the Warren Court in 1961, and the court said, we don't understand this complaint. Women have the best of all possible worlds. They can go down to the clerk's office and sign up to be on the jury rolls. But if they don't sign up, they're not there. How many men would sign up if they were not obliged to serve? And what is a law like that saying to people? It's saying, men, you are essential to the administration of justice. Women are expendable. We don't need them to be part of the system of justice. So that's where the Warren Court was. They just didn't get it.
Right.
And you can imagine Gwendolyn Hoyt when she was told that women have the best of all possible worlds. But it was exactly 10 years later, in 1971, that the Burger Court...
Warren Burger is now Chief Justice.
Yeah, he began to move in a new direction. And that was in a case called Reed v. Reed. It was the first gender discrimination brief that I wrote in the Supreme Court. I'd written such briefs earlier for courts of appeals. But Sally Reed's case, Sally was an everyday woman. She made her living by taking care of elderly or disabled people. She had a young son, and she and her husband separated and then divorced. Sally got custody when the boy was what the law calls of tender years, needed a mother's care. Then when the boy reached his teens, the father said to the family court, now he needs to be prepared for a man's world, so I should have custody of him. Sally fought that. She thought the father would be a bad influence on her son. Sadly, she was right. The boy became severely depressed and one day took out one of his father's many guns and committed suicide. So Sally wanted to be appointed administrator of his estate, and she applied. Not for any economic reasons. There was very little there. The father, perhaps out of spite, applied a few weeks later, and the probate court judge said, Sally Reed, the law controls what I must do in your case. It reads, as between persons equally entitled to administer a decedent's estate, males must be preferred to females. Well, Sally took that case on her own dime through 3 levels of the Idaho courts. She was from Boise, Idaho. And then someone on the ACLU board spotted it when it spotted the Idaho Supreme Court's turn down and said, this is the case that will turn the Supreme Court in a new direction. And it did. The Supreme Court took Sally Reed's case and in a very low-key opinion held that a statute saying males must be preferred to females is a violation of the equal protection principle.
And who wrote the brief for Sally Reed?
I did.
You did?
Yes, I did. Her lawyer from Boise, Idaho argued it, but I wrote Sally Reed's brief.
When people say that you are to the women's movement what Thurgood Marshall was to the civil rights movement,
I feel very uncomfortable with that comparison.
Because?
It's right only to this extent. We definitely copied Thurgood Marshall's method. That is, he proceeded step by step up to Brown against Board. He didn't tell the court in the first case, you have to declare separate but equal in any and all circumstances unconstitutional. He had building blocks, so we copied that. But there was an enormous difference. During the 70s, when I was litigating these gender discrimination cases.
Most of them successfully.
But my life was never in danger. Thurgood Marshall would go to a small town in the South. When he got up in the morning, he didn't know whether he'd be alive at night. I never. My life was not in danger as his was.
So a different kind of courage for him.
Enormous courage. And another thing, the NAACP, which he headed, headed the Legal Defense Fund, it was the only show in town. African Americans, if they wanted to be represented, well, it was the NAACP.
Right.
When the women's movement was underway, it was more dispersed. There were cases coming to, sometimes to private lawyers, sometimes to groups other than the ACLU.
Yeah, but I'm telling you that when they talk about the women's movement and they talk about the legal argument and the architecture that helped prevail in the courts, they put you at the front of that parade. And you know that.
Well, as I said, I was fortunate to have that position. And when I was a teacher at Rutgers and deciding where I should affiliate, with what group should I affiliate, I picked the ACLU because it's not women's rights, it's people's rights. It's men's rights as well as women. I called it the struggle for equal citizenship stature for men and women. And a number of the cases we brought were on behalf of men who were disadvantaged simply because they were men. The laws reflected this pattern. There were men, they were the breadwinners, they represented the family outside the home. And then there were women who took care of the home and the children. The common law rule and the civil law rule were identical in this respect. The man was the head of the household. He could choose any mode of living, and she was obliged to conform. In the civil law, the states in the United States that have their inheritance from Spanish and French law, it was called the head and master rule. The man was head and master of the family.
Then in 1980, President Jimmy Carter appoints you judge of the appeals court of the District of Columbia, a place which has been the breeding ground of justices of the Supreme Court, including Anton Scalia.
And Justice Berger.
And Justice Berger.
And Justice Thomas.
And Justice Thomas. And would-be Justice Bork.
And the current Chief Justice. Right.
Yeah. Were you excited when you got a chance to sit on the bench one step away from the Supreme Court?
Was I excited?
Yeah.
I was excited when Jimmy Carter became president and made it his mission to change the complexion of the U.S. judiciary. Now, people ask, did you always want to be a judge? For a young woman in studying law in the late 1950s, it was an impossible dream. Women were not judges. But then Jimmy Carter looked at the federal bench and said, those judges, they all look like me. But that's not how the great United States looks. So I will choose judges from all of the people and not just some of them. He was determined to appoint members of minority groups in numbers and women in numbers, not just as one at a time curiosities. He had only 4 years in office, and he had no Supreme Court vacancy to fill. But he appointed about 25 women to the federal trial bench and 11 to courts of appeals, and I was one of the lucky 11.
Do you think he might have appointed you to the Supreme Court if, in fact, he'd had a vacancy to fill?
It was too soon. He would have appointed Shirley Hufstetler.
Right, right.
She was placed on the Court of Appeals by President Johnson in 1968. She was a great judge. Carter made her the first ever Secretary of Education.
Right.
And when he made her Secretary of Education, then there were no women on any federal appellate bench. He determined to change that. If he had a vacancy, there is no doubt he would have appointed Shirley Hufstetler.
Now, so you moved to D.C. Marty comes to D.C.,
yes.
Gets a job professor at Georgetown, is a tax lawyer. Described, I mean, he was a pretty good tax lawyer.
I would say, in my not totally unbiased opinion, that he was the best tax lawyer in America.
Other people have said that. He described himself, I love his sense of humor. He described himself as having a professional life devoted to protecting the deservedly rich from the predations of the poor and downtrodden. And then Ross Perot wanted to endow a chair, and he couldn't get him to the idea. So Ross Perot said, I think the story goes, I'm going to appoint a chair, create a chair for him at, I think it was maybe at Jerry Falwell's.
Oral Roberts, yes.
Out in Tulsa.
We wouldn't tell. Ross said he wants to set up the Martin D. Ginsburg chair. Yeah. We should pick the school.
Yeah.
And we were a little hesitant because we said in the Jewish religion, you don't name things after people till they're dead. And he said, don't tell me that. I have named the symphony in Dallas, the Mort Meyerson Hall.
Right.
And Mort's grandmother in the Bronx said that was okay.
Yes.
So when we still hadn't identified a school, he said, I will set up the Martin D. Ginsburg chair at Oral Roberts University. And we said, Ross, I don't think the founder of Oral Roberts would want to have them on. He said, I've spoken to him personally. He said, we are all God's children. and he would be delighted to.
So then Georgetown was chosen.
So we named Georgetown with the agreement that the chair would not be filled while Marty was on the faculty, but instead the income would be used for the dean's discretionary account. That's why the dean of Georgetown was very fond of Marty.
You made at NYU something that has become known as the Madison Lecture. And you made the point that you thought the decision in Roe versus Wade was too broad because it gave a singular target for all those who oppose abortion.
At the time of Roe v. Wade, abortion law was in flux across the country.
Different states had different laws?
Yes, so some states, including my own, New York, gave a woman access to an abortion in the first trimester, no questions asked. It was just her decision. Others had moved to grounds like a risk to the woman's health, the pregnancy was the product of a rape, or
incest.
Incest, yes. Others had conditions. You had to have the approval of 2 doctors. So the law was changing across the country. The people who wanted to keep the prohibition of abortion strong were fighting in states, sometimes winning, sometimes losing.
So they were fighting a lot of wars in different places, if you can call it a war.
Yes.
And all of a sudden there's one target,
right.
Roe versus Wade. And you don't think that's in the best interest of people who believe?
I thought if the court had done in the reproductive choice area what it did in the gender discrimination cases, that is, one step at a time, always in the right direction, but no giant step, a progression that made it seem like the next step was natural. But Roe v. Wade made every restrictive law in the country, even the most liberal law, unconstitutional in one fell swoop. The court had done it all. So the people who favored a woman's decision, they won. They kind of retreated.
Right.
And the other side had, as you said, a target to rally around. And they could hit at that target and accuse the unelected justices of the Supreme Court of having made a major policy decision. Now, in truth, in 1973, when Roe v. Wade was decided, it wasn't controversial among the justices. There were only 2 dissents, Justice White and Justice Rehnquist. The chief had assigned the opinion to Justice Blackmun.
Right.
But Roe marked the point where the states began placing more and more restrictions, and those cases came to the court, and by and large it upheld the restrictions.
Right. Might not have been that way if you built up.
That was. Right. I had no crystal ball. Hindsight, we can speculate what would have happened, but I thought it would have been a more secure way to go, to take this one step at a time.
The other thing that interests me about it, when you think about what you have said in speeches and in writings and about the law, is that you think that what the court says ought to be also a conversation.
Yes.
With legislators.
Yes.
And legislatures, state, federal, the Congress. And in fact, it's happened that way in some cases, in which a decision which may not go in the way you want it will end up, because of a dissent, starting a conversation so that a Congress will either take a law and amend it to take away something that they don't think is necessarily right, or add to it to strengthen something.
My best example of that conversation is the Lilly Ledbetter case.
Tell me about it.
Lilly Ledbetter was an area manager at a Goodyear tire plant, one of very few women doing that kind of work. One day, she found in her mailbox a slip of paper with a series of numbers. The numbers were the compensation received by other area managers. Lily's pay was at the very bottom. A young man who had very recently come on board was earning more than she was. So she began a lawsuit under Title VII, which is our principal anti-employment discrimination, anti-discrimination law in employment. And she did rather well. She got a nice jury verdict. But her case came to this court. The majority, the 5-member majority, said she sued too late. How could that be?
A procedural question.
Yes, the timing. What they relied on was a provision that said a person complaining of discrimination in employment must complain within 180 days of the discriminatory event. And Lilly had been working at this job for over a decade. Far too late, far longer than 180 days. My view of the case was every paycheck she receives renews the discrimination. So she has 180 days from the latest paycheck to complain. And then I tried to explain why Lilly Ledbetter didn't sue earlier. As a woman holding a position that traditionally has been held by men, she didn't want to rock the boat. She did not want to be seen as a troublemaker. Besides, they didn't give out pay figures. The employer didn't give out pay figures. But even if she knew that she was discriminated against from the beginning, and she sued as soon as she possibly could, if she had sued early on, we know what the defense would have been. It would have been, it has nothing to do with Lilly being a woman. It's just she doesn't do the job as well as the men. But then, year after year, she gets good performance ratings. So they no longer have the defense. No longer have the defense she doesn't do the job as well. They've said she does the job as well or better. So now she has a winnable case. And the court said she sued too late. I explained that in my dissenting opinion, and the tagline was, the ball is now in Congress's court to correct the error into which my colleagues have fallen.
And that's exactly what they did.
And that's what Congress passed, the Lilly Ledbetter Fair Pay Act. It was the first piece of legislation President Obama signed when he became our president.
There's also, in 1993, you're appointed to the Court of Appeals, and you're on the Court of Appeals, and then you're appointed by President Clinton 1 year after he became president to be on the Supreme Court and Associate Justice of the Supreme Court. Justice Rehnquist is the Chief Justice. You have a good relationship with him.
I had a very good relationship.
You liked him?
Yes.
He, as I remember, he loved librettos and he loved...
He loved Gilbert and Sullivan.
And Gilbert and Sullivan, yes. And he appointed you to write the VMI case involving...
I can't explain the inner workings of the court on that particular point, but this I can't say. It was a 7-1 decision. That is, the chief did not join my opinion, but he joined the judgment.
Right.
Scalia was the only dissenter. Justice Thomas was recused. He couldn't sit on the case because his son at the time was a student at VMI. So it was a 7-1 decision, and Justice Scalia's dissent aimed more at the chief than it did at me. I guess he expected what I would do, but he was surprised by the chief.
Many consider that the most important opinion you've ever written. Do you?
It remains to be seen. My time is far
There may be
from
one around the
over
corner. Yes.
here.
First
Yes.
Monday in October, not far off.
I'm very fond of some of my dissenting opinions,
Yeah.
including...
You are, as much as some of the majority opinions,
Yeah.
as in the
Yes.
Lilly Ledbetter case.
Well,
and,
one that Congress...
Yeah.
Yes, Congress could still do something about it, but it was the so-called Shelby County case.
Yes.
Where the court held, invalidated the key provision of the Voting Rights Act of 1965, even though that legislation had been renewed time and again by Congress, every time with overwhelming majorities on both sides of the aisle, Republicans, Democrats. But the court said that the coverage formula, the coverage formula was that a state that had been a discriminator in the bad old days, when African Americans were not allowed to vote, could not adopt any law relating to elections unless they pre-cleared it through either the Department of Justice, Civil Rights Division, or a special three-judge court in the District of Columbia. So things were working pretty well under that clearance system. The court said the formula of who belongs in the discriminatory camp was outdated, and Congress had to do it again. It would be a hard thing for Congress to do again. What senator or representative would get up and say, my state or my county is still discriminating, so better keep us under federal surveillance? The law itself had a built-in mechanism for getting out if you were no longer discriminating. It was called the bailout provision. And if you had shown that for X number of years there had been no discrimination in voting, then you could come out from under the system. And I thought Congress had identified a very good way to get out. Anyway, that's a dissent that
it made
that I thought was
important.
Yes.
When you came to the court, Senator O'Connor was your good friend.
Yes.
And when she left, you said that was a turning moment.
When Sandra left, it was a very lonely place for me to be. That is, the perception of the court, we come and sit on the bench, and there's the audience of spectators, including the school children that come in and out of the court at 10 minutes a time. They looked at the bench, and they saw 8 rather well-fed men up there. And then there was a small little woman. It was the wrong perception.
Yeah, exactly. Yeah.
But now...
The optics, they say now.
Yes. I've been just over 23 years, so I sit by seniority close to the middle. Justice Sotomayor is on now my left side, Justice Kagan on my right side. We're all over the bench. We look like we are 1/3 of the court.
Yeah.
And my newest colleagues are not shrinking violets. They take a very active part in the colloquy that goes on at oral argument.
Yeah, but you are a questioner. You love to ask questions. You love to lead the questioning. I mean, you're also, as we know, previously a litigator.
Yes.
But you're there and you're curious, and you're no shrinking violet. You.
Yes.
You may be 5'4".
No, a little less.
Less. But your voice is strong and is heard by those advocates standing in front of you. Yes?
Yes.
You love it. You love it.
I do.
What do you love? Is it the argument? Is it what?
It's the constant thinking, the constant thinking, and to see if I can get counsel to help reduce the level of controversy by asking a question designed to elicit a yes response that will narrow the area of disagreement.
Justice Scalia.
Yes.
Many people, have been fascinated by the fact that Ruth Bader Ginsburg and Antonin Scalia were friends. Whether good friends or not, I don't know. We all know that you both loved opera. You have told me when we talked in your chambers that he was a better singer than you are.
He was a much better singer. Justice Scalia had a very good tenor voice. In fact, he had been, when he was an undergraduate at Georgetown, he was in the Glee Club at Georgetown. I am a monotone.
His death shocked you.
Yes.
Do you miss him on the court?
Of course I do.
Because
it's a paler place without him.
It's a what?
Paler.
A paler place.
Paler.
It doesn't have as much color and as much vibrancy and as much...
Because he was a wonderful storyteller. He had an uncanny ability to make even the most somber judge smile.
Yeah.
He told many jokes. He's very good-humored. We shared a passion for opera, and we both genuinely cared about family.
Yes.
Yes, I did.
They brought you back to Harvard Law School and to honor you, and lots of people there in terms of clerks and a lot of other people. And you talked about the balance, the importance of family, and the balance that you had found between the law and family. And you think it's important?
To have a full life?
Yes. You spoke about it.
Yes. I said, when I was going to law school, my daughter was 14 months when I started. Right. So I would take my classes, go to the library, study hard, but 4 o'clock was when the nanny went home, and that was Jane's time, my daughter's time. We would go to the park, we would play games, I would read to her, and then after she was bathed and fed and went to sleep, I went back to the law books with renewed energy.
Yes.
Energy. So
yes.
I described it as the two parts of my life. Each part was a respite from the other. Yeah. It was by 4 o'clock in the afternoon I had enough.
Exactly. Take a breath from the intense intellectual engagement.
And then it was fun to be with Jane.
Right.
But it was.
And she turned out to be a lawyer as well.
She is a distinguished law professor at Columbia Law School. And
was one class, I guess, above or below Justice Roberts.
Below. One class below.
At Harvard.
Yes.
Yeah. When you look at what happened after Scalia died, and Garland, the president wanted to appoint Garland. He couldn't get it to bring to a vote, and so you're left with 4 and 4.
Yes. 4 and 4. 8 is not a good number for a collegial body that sometimes disagrees. But they sometimes disagree, I should stress, because the press doesn't explain this as it should.
Explain it.
We are unanimous, at least in the bottom line judgment, much more often than we divide 5 to 4. So I'd say we are unanimous in about 40% of the cases, and the sharp division.
Unanimous in about 40% of the cases?
Yes, at least as to the bottom line judgment.
Right, and then what the decision will be.
Yes. And the divisions, the 5 to 4 or 5 to 3, if we're only 8, they will be maybe 20%. So we agree much more than we disagree. Even so, if we divide 5-4, we are unable to to issue a binding judgment. What we do is we automatically affirm the decision of the court below. No opinion is written, so no reasons are given, and the affirmance has no precedential value. So if we divide 5-4, it's just as though we denied review.
As if you didn't do it.
That's right, as if we didn't take the case.
That's right, exactly.
Yes.
And that's not good, because you want the Supreme Court to be the court of last resort.
Yes.
And in the sense of this, you're making the Court of Appeals the court of last resort.
That's right.
And that's not why we have a Supreme Court.
And it could be worse than that. It could be that we took the case because courts of appeals disagreed.
Yeah.
If we're unable to decide the question, you can have one federal law in one area of the country and the opposite federal law in another part of the country. So it's important that the Supreme Court be able to resolve conflicts among other courts about what the federal law is. That's why 8 is not a good
So whoever
number.
becomes president will have, when they arrive in the White House, an opportunity to appoint a new Supreme Court justice.
That's one scenario. Another possibility is after the election, the Senate will act.
What would you like to see the Senate do?
Well, I would like to see the court have a full House by the time this term ends.
You'd like to see the court have a full
Have
House
9 members, yes.
before this term ends.
Yes.
Yes, which is, this term ends.
We stop hearing cases in April. We're still writing opinions in May and June, but the last sitting to hear oral argument is at the end of April.
Some people say that if Hillary Clinton becomes president, it's a very close race now, that you would likely see a Democratic majority more than you've seen in a long time. You've got 4 now, 4 liberals, for lack of a better classification. I mean, you could see a very different court.
You could, but I resist the notion that if you are a Democrat, then you are, quote, liberal. And if
I know that it was too easy, but I was...
Yeah, well, just to think of John Paul Stevens, appointed by President Ford, David Souter, appointed by the first President Bush.
Yes.
Those two...
Didn't turn out the way they expected.
They were not, quote, conservative.
No, they weren't. And in fact, conservatives went crazy, as you know.
And it's hardly the first time. Think of the great liberal Chief Justice Earl Warren, appointed by Eisenhower.
Right.
Brennan, a Republican. Bill Brennan was a registered Republican, and he was, when he was on the New Jersey Supreme Court, he was also appointed by Eisenhower.
Yeah. You've had successful battles with cancer, heart stent. You look and seem to me to be in good health.
Yes,
you have energy.
Yes.
I've spent the last 2 hours with you. No thought of retiring.
I have said that I will hold this office as long as I can do the job full steam.
And you're doing it full steam.
So I know that this year I'm okay. At my age, I'm 83, you have to take it year by year. I'm hopeful that I have many years. I will have many years of good health and good thinking ahead, but one never knows.
And you point to the fact that Louis Brandeis was appointed at 60 and you were appointed at 60.
Yes.
And he served until his 80s.
Until he was 83. I can't use Brandeis anymore because I have served longer than have.
Well, do you have another model to suggest us?
Well, of course I can say my dear colleague, Justice John Paul Stevens, who stepped down when he was 90.
Yeah. When you look at the court, and is it essentially, you take pride in institutions. I mean, it is said about you, you feel the weight of the and maybe everybody does, but you love and feel the institutional quality of the Supreme Court?
I think the Supreme Court is the most respected high court in the world. No, it wasn't always that way. It may be a rumor or a legend, but President Andrew Jackson was reputed to have said, well, the Supreme Court said that about how the Cherokee Indians should be treated fairly. The Supreme Court said that. Now let them enforce it, because we have no purse strings and we have no guns at our disposal. And yet, when the Supreme Court speaks, people listen. Think of...
It can decide elections.
I don't think, if you have in mind the one-of-a-kind case, Bush v. Gore, I don't think it decided the election. It decided it sooner, but the outcome would have been the same, because the election would have been thrown to the House of Representatives, which then had a Republican majority, so it would have been a victory for Bush anyway, but it would have come weeks and weeks later than the Supreme Court decision.
But just along about the significance and the respect for the court, after the decision, which I think was 9-0 in the Watergate case,
yes,
everybody understood the court had spoken, and that was it.
Yes, and the president turned over the tapes and resigned from office the next day. It isn't the first example. Think of Harry Truman, who seized the steel mills in the Korean War. And when the court said, "You don't have that authority, Mr. President," he immediately told the Secretary of Commerce, "Give the mills back to the owners." That in many places in the world, the fact that a court speaks doesn't mean that the executive legislature will accept the decision.
Yeah. I mean, one thing that you disagree with Antonin Scalia was that you should take a look at international law too.
And I have tried to clarify that international law is not foreign law. And what does it mean? International law is a law that governs relations among nations. We are a nation of the world, therefore we are governed by what our Constitution calls the law of nations, which is international law. What we are not governed by is the law or the constitutional decision of some other court, say in Israel or in Britain or in South Africa. So foreign law is not an authoritative source for us, but it can be something of persuasive value. That is, there are good minds thinking about hard problems common to humanity. There are good minds on courts all over the world. One thing
that I want to ask you about this, then I'm going to close this. You've been wonderful. It is this. Televising the court, seeing justices write more books, speak out more about the conversation of America. Where do you come down on that? Televising the court.
I am neutral on that question. I will say, as long as any one of my colleagues is apprehensive about it, I would not push.
Meaning it might affect the way they conduct themselves?
Yes, I think that the most weighty objection is it gives the public a false picture of what an appellate case is. That is, if you televise a trial, everything's happening right out in front of you, before your eyes. You see the witnesses, see the judge giving a charge to the jury. But in an appeal, much more important than the oral argument is the written part. I mean, the first thing I do when I prepare for a hearing on a case, I read all of the decisions written before ours, so the trial court decision.
District court or appeals court.
And then I turn to the lawyer's briefs.
Right.
And then maybe I will read what scholars have said about it.
Or an amicus brief.
So, yes, and in important cases, we have dozens, or sometimes over 100 friends of the court who tell us what they think about the hard question. So you come armed to the teeth by the time you're on the bench. After doing all that reading, you are inevitably leaning in one direction or another. You don't come on the bench with an empty mind, not with a closed mind either, but you have thought about the case. We don't want the public to get the impression that an appellate argument is a debate. That is, the superior advocate will win. It's not at all what it is. The written component is ever so much more important than the oral component.
This conversation has been about the past, not about the future, and obviously I wouldn't ask you about cases that are coming up because you wouldn't tell me. Anyway, I know. But you do see more speeches, more appearances. I'm interviewing, I've interviewed lots of judges, Chief Justice Rehnquist and Justice Breyer and Justice Scalia and others. And I think it's a good idea. I think it's a good idea because we have to understand who these people are that have the power to impact our lives and to understand how they see their work and to understand. Now, obviously, we obviously don't want justices, telling us how to vote. We don't want justices tell us, what's right and wrong about everything, but we do like to know where their legal mind is, and what shaped it. Your hero was Louis Brandeis. It says something about you. Your relationships on the court, all of that. I mean, it seems to me it makes for a richer understanding of the court, and you contribute to that.
I'd like to mention that one tremendous contributor is Justice O'Connor with her iCivics program.
Yeah,
and this is school children nowadays don't learn about civics the way I did when we had a daily civics class. Now they're concentrating on the math and the reading scores. So civics tends to get cut, music, art, it's too bad. But Sandra started this iCivics. It's pitched to middle school children, and it teaches them about government, about the court, and why the court is different, how the court is different from Congress, and does it in a way that is fun for the children. So I thought that was, first she spotted the need for that kind of education, and then she found a way to deliver it that would be appealing.
She's made it, not only that, and that clearly, and part of that, she's made us, in lots of ways understand, a lot more about the judiciary, elected judges, all the kinds of different variations there are in the American judicial system. Finally, this book is dedicated to Marty, dear partner in life and constant uplifter.
Yes.
What do you mean by constant uplifter?
Marty made me believe that I was better than I thought I was. He was a most unusual man. He was the first boy I ever dated who cared, really cared that I had a brain.
Yeah.
And we were best friends before we became very close. And Marty was a man so secure in his own intelligence, his own competence, that he never regarded me as any kind of a threat. On the contrary, he was always in my corner, always cheering me on, because his notion was, if I decided I wanted to spend the rest of my life with this woman, she must be pretty special.
He left a letter.
Yes.
Tell me about that.
When the When the hospital called me to tell me that he had taken a bad turn for the worse, and there was nothing more they could do for him, so I went to the hospital. I wanted him to die at home rather than in a hospital bed. And I was checking to make sure that we took all of his belongings. I pulled out a drawer, and on a legal pad, he had written a letter to me. It was the most beautiful love letter. I suspect he wanted me to find it. I keep it in my bedroom, and to this day, look at it now and then when I feel like I need an extra shot of courage.
He said to you, you were the love of his life, more than anything. And he said he understood that he had to make hard questions, that he knew he had terminal illness, and he said,
he said, I hope you will agree with my
decision.
But I will love you nonetheless.
Exactly.
If you don't.
Thank you for this time. I enjoyed it very much.
I did too.
Thank you.
It was good to talk to you.
Thank you. The book's called My Own Words, Ruth Bader Ginsburg, with Mary Hartnett and Wendy W. Williams. Thank you for joining us. See you next time.